This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about claims and why a demand for reasons for the termination of an officer of a corporation is not a claim, and a claim by any other name is just that. It is imperative that every insured report potential claims to their insurers so as to avoid denial of the claim. In the case entitled Jeffrey B. Scott versus certain underwriters at Lloyd's, London, et al., the United States Court of Appeal for the 11th Circuit on August 25, 2025, explained the need for a claim if there is to be coverage available for defense or indemnity. The appeal arose from a coverage dispute under a director's and officer's insurance policy. Jeffrey B. Scott, the plaintiff-appellant, was terminated for his role as CEO, President and Secretary of Gemini Financial Holdings, LLC, in October of 2019. Following his termination, Scott threatened legal action against Gemini, and Gemini sent him letters accusing him of misconduct and demanding return of company property. The D&O insurance policy issued by the underwriters at Lloyd's and others defines a, quote, claim, close quote, as a, quote, written demand for monetary damages, non-monetary or injunctive relief against any of the insureds, close quote. It also provided coverage if the chief executive officer, chief financial officer, or chief actuary of the company gives notice of circumstances that may reasonably be expected to give rise to a claim. Scott submitted a letter to Lloyd's on November 23, 2019, entitled Notice of Claim, enclosing Gemini's letters. Lloyd's denied coverage, determining that no claim against Scott had been made under the policy. Scott sued Lloyd's for insurance coverage, but the district court dismissed the case. Scott's arguments included that his documents reflected a claim or a notice of circumstances for a future claim. In diversity cases arising under Florida law, a federal court is bound by the law articulated by the federal Supreme Court. Unambiguous policy terms are interpreted according to their plain meaning as written. If the Florida Supreme Court has not spoken on an issue, Florida District Courts of Appeal decisions control absent persuasive indication that the Florida Supreme Court would rule otherwise. As a matter of Florida law, unambiguous policy terms are interpreted according to their plain meaning as written, which is a rule that's followed in almost every state. The letters cited by Scott do not contain a demand for relief against him. They explain why, in Gemini's view, Scott was terminated and request that he preserve documents and return company equipment. The letters Gemini sent did not request monetary payment nor legal remedies. Instead, they assert a cause for Scott's termination and outline expectations for his post-employment conduct. Viewed in the light most favorable to Scott, these letters are anticipatory posturing for a future dispute and intent to review certain workplace conduct by Scott, but they are not present demands for relief. Scott's November 2019 letter did not identify circumstances that would lead to a claim against him. Instead, it mostly reflects his demands against Gemini over a putative wrongful termination. Scott was not one of the specified officers who could provide a notice of circumstances under the policy when he sent his November. Therefore, the Circuit Court concluded that the District Court correctly rejected Scott's arguments that his documents reflected a claim, or in the alternative, a notice of circumstances for a future claim, because he was no longer CEO and couldn't even give the notice required. The District Court held that no claim, as defined in the policy, was made against Scott during the policy period, and that Scott did not provide a notice of circumstances to trigger coverage. The court also noted that the letters from Gemini did not request monetary payment nor legal remedies, but instead asserted a cause for Scott's termination and outlined expectations for his post-employment conduct. And that's why the 11th Circuit affirmed the U.S. District Court. In my opinion, insurance is nothing more than a contract like any other contract. It is interpreted by dealing with the usual meaning of the words used. Letters accusing a fired CEO of misconduct and demanding the return of company property was not a claim, nor was the fired CEO's request for detail was a claim as defined by the policy. The threat, if made to an intelligent corporate officer or insurance consultant, should have resulted in a report of a potential claim. But the insured did not so advise the insurers of a potential claim, and there never really was a claim made by Mr. Scott against the corporation. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,150 blog postings. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.